Hi, everyone. Good afternoon. Welcome to the second of our 3 CLE panels hosted by the CARES Clinic at Villanova Law in conjunction with the Our Tech Futures convening. Thank you all so much for joining us today. My name is Tanya Valdez, and I'm an adjunct professor in the CARES Clinic teaching alongside Francis Kramer. We are absolutely thrilled about today's panel, which is called Retaliatory Surveillance: Can the Constitution Protect Us? Before we begin, I just have a few quick announcements. If you have a question during the program, please use the Q&A function that's at the bottom of the Zoom screen. We'll get to as many questions as we can at the end of the program. For those of you who are licensed in Pennsylvania, there's one free CLE credit available for this panel, thanks to a generous gift from our donor, Joseph Azrak. We'll also provide an out-of-state certification to those who request it through the CLE registration and evaluation form, which was sent to you from Eventbrite and will also be linked later in the chat. If you're seeking CLE credit for this program, you'll need to fill out a course evaluation. And as part of that evaluation, you'll be asked for 2 secret words to help verify that you attended the program today. They'll be given out at different points during the program, and it's your responsibility to write them down because per the Pennsylvania CLE board rules, Villanova is not allowed to share the words with you if you miss them. So we'll try to announce slowly and loudly that we're about to say the secret word, and then those will be given out. And if you have any questions about CLE credit or other logistics, please just use that same Q&A function. And now it's my pleasure to introduce our fabulous moderator for this panel, Professor Jennifer Lee Coe. She's a visiting professor at UC Irvine and at the University of Washington's Immigration Clinic. She was also a Take Back Tech Fellow this year, and her scholarship focuses on the convergence of the immigration enforcement and criminal justice systems, the legal frameworks governing deportation, and the federal court's treatment of immigration claims. And with that, I will pass it over to Professor Coe.
Great, thank you, and good afternoon. Well, I'm honored and excited to moderate the CLE panel on retaliatory surveillance of immigrants' rights activists. Can the Constitution protect us? We have a panel of experts and practitioners: Sejal Zoda of Just Futures Law, Jumana Musa at the National Association of Criminal Defense Lawyers, and Vanessa Del Valle of Northwestern Pritzker School of Law. Each of our panelists brings deep, unique, and complementary practice experience on different dimensions of surveillance and retaliation. And the panel today will discuss different surveillance strategies and tactics used by law enforcement. And it will also address how people accused of crimes and community activists can defend themselves from invasive technological surveillance using a range of tools, from constitutional law to statutory provisions, legal claims arising under federal and state law, as well as claims that arise in both the civil and the criminal contexts. And in doing so, our hope is that the panel will also connect 2 themes that at first glance may not seem to be related, but really are. And those are, first, the existence of government-sponsored retaliation against protesters and organizers, as well as, second, the use of surveillance tools by the government. Both of these issues arise over a continuum of scenarios facing immigrants or people who engage in advocacy when they encounter surveillance technology. Indeed, this Take Back Tech convening is an ideal place in which to consider how these 2 trends of retaliation and surveillance play out and reinforce each other. And the Take Back Tech Fellowship, hosted by Just Futures Law and Mi Gente, has been bridging these 2 spaces and creating conversation for some time. I'll mention that in just a few weeks, a report prepared by the University of Washington School of Law Immigration Clinic will also provide a deeper dive into how retaliation and surveillance have been experienced by various grassroots advocacy organizations around the country for the past several years. But with that, this is how today's panel will proceed. We've asked each panelist to speak for about 15 minutes and to share briefly what they're seeing in their work with respect to surveillance and retaliation, to explain what legal claims they've raised in those contexts, to address some of the pros and cons of the legal interventions that they've used, and where possible to include practice tips in developing and inserting these claims. We'll hear from Sejal first, followed by Jumana, and then Vanessa. This should all in all leave us with about 5 to 10 minutes for questions, which I'm going to try to reserve at the end. Also, there's a secret password, as mentioned, for CLE credit. And so the secret password, the first of two, is, drum roll, it's sunflower. Okay, so sunflower is the secret password that is the first of two secret passwords that you'll need in order to receive continuing legal education credit if you're an attorney. Sunflower again. Okay, so with that, let's first hear from Sejal Soda, who is the co-founder and co-director of Just Futures Law. Again, JFL is a co-sponsor of today's convening and an organization whose core priorities include litigation, advocacy, and policy to dismantle ICE and police surveillance, and they've been active in leading the way in combating retaliation against people of color and immigrants protesting government law enforcement activity. So Sejal, I'm going to hand things over to you.
Okay, great. Can you guys see my screen?
Yes.
Okay, awesome. So thank you, Jennifer. I want to say that I'm thrilled to be on this panel with so many badass, brilliant women. And I just want to do a shout out to Jennifer and U of Washington's activist retaliation report, which is going to be released soon, which is amazing and will really put together a lot of what we're talking about today. So much of this convening has been about DHS and police use of technology to surveil, target, and silence immigrant communities, communities of color, and over police communities. Challenging this tech policing and retaliation are core areas of our work at JFL, and we believe one of the civil rights issues of the day. So what are we seeing on the ground? Throughout the convening, we've gotten snapshots of how DHS has surveilled activists, and I want to point out one example that I think encapsulates many of the tactics that DHS employs, and that example is of Maru Mora Villapando. Many of you know she's a lead organizer for La Resistencia, a grassroots group working to shut down the Northwest Detention Center in the state of Washington. And they are getting very close to shutting it down. It's awesome. ICE very much viewed Maru as an instigator behind the hunger strikes at the detention center. You can look at this email here on the slide. It says that, those emails also tell us that ICE placed her in removal proceedings because they were threatened by the power of La Resistencia's organizing, right? They actually put it in an email that supporting her might reduce her clout, which is just incredible. So they've retaliated by trying to deport her. How did they surveil her? So we've heard about ICE's direct access to driver's license information from Caitlin and Tawana. And here ICE accessed Maru's information from the Washington DMV, including her home address, where they mailed Maru's deportation papers. And in Washington, they did that in violation of state law, right, which precludes that information sharing. But Maru was not the only one. Through public records requests, we know that ICE ran thousands of DMV searches to locate entire immigrant communities in Washington. Second, ICE also bought Maru's personal data from data brokers through Thomson Reuters Clear. We've heard a lot about Clear and how they aggregate data, create a whole profile of a person, right, based on Maru's telecommunication records or utility records, records of her family, which again, they use to facilitate her deportation. ICE also regularly monitored Maru and La Resistencia's social media, which they would then use to do in-person surveillance at their public events, right? So they would learn a protest was happening, and then they would show up and sometimes record it. ICE has records with social media surveillance companies like Babel Street, and records show us that they've done this to many other groups like Grassroots Leadership, Migrant Justice. In Migrant Justice's case, ICE also enlisted a community informant to gather information, and they went on to place, ICE went on to place 20 members in removal proceedings. And so, but, Maru's case is not unique. A recent study done by NYU identified over 1,000 instances of retaliation against immigration organizers during the Trump era. So how can we challenge this mass surveillance and retaliation, which has a chilling impact on people who want to speak out? I would encourage you to at least consider a First Amendment claim whenever you're dealing with retaliation or surveillance. Over the last 4 years, several activists and grassroots groups have raised First Amendment retaliation claims against the Trump administration. And while those claims are hard, in some cases they're really hard, a number have survived motions to dismiss, summary judgment, and resulted in grants of habeas. So what have they accomplished, right? That's one of the questions that Jennifer posed. In some cases, the litigation and an accompanying stay has prevented the deportations of activists. I think about the example of Ravi Rugbeer. His case has gone to the US Supreme Court and back, but he's still here. And even if the claim doesn't ultimately prevail, the litigation and stay may give your client the time she needs to pursue other relief. It has yielded voluminous discovery. An example of that is our case NWDC Resistance v. ICE, in which La Resistencia and CareW, they challenged ICE's pattern of retaliating against immigrant activists. And we've now survived 2 motions to dismiss, and we've gotten tens of thousands of pages in discovery. And discovery is instrumental to helping us learn about how ICE tracks activists, the tech that they use, right? And of course, knowing that information can help groups advocate for digital sanctuary policies, and of course, empower grassroots groups to tell their own story of retaliation to help build power. The third thing is, press. The press that accompanies litigation can help raise public awareness about the issue. An example I think of is, right after the New York Times printed an op-ed from a church plaintiff in the sanctuary fines litigation, which challenges the government use of fining immigrants who've taken sanctuary in churches, the Biden administration rescinded the Trump era policy, right? So press can be very powerful. And lastly, in some cases, you might win relief. In Migrant Justice's case, they settled in exchange for deferred action for the plaintiffs, money damages, the reissuance of a First Amendment memo. And I'll note that case went straight to settlement, in part because of the damaging information the plaintiffs obtained by doing public records requests first, and then, bolstering their complaint with that information. Lastly, I can't really talk about this without making a pitch for movement lawyering. If you're considering this type of litigation, please coordinate it with organizing around the issue. JFL, we generally bring our litigation in conjunction with larger campaigns that the plaintiffs and other grassroots partners are running, where the litigation is really only one tool in the toolbox. We aim to center the leadership of our clients and grassroots partners, directly impacted organizers and individuals, so that in the NWDC resistance case, right, it's really La Resistencia and other organizers who are engaged in the communications and press work, right? They're having meetings with the new administration. They decide when to organize an action. And we really think this is the best way to change policy, to build power, and elevate issues in the public. So what do you need to bring a First Amendment retaliation claim? This varies a bit depending on the circuit, but the test is essentially, that the speech, I'm sorry, my slide didn't, okay. But that the speech or conduct at issue was protected, that the defendant took adverse action against the plaintiff, and that there was a causal connection between the protected speech and the adverse action. You're always going to have to show some causal connection. So what sorts of evidence have the courts looked to? I have tried to pull some helpful language from some of the cases, in the Rueda v. DHS case. The court said that the proximity and time between Rueda's outspoken advocacy her arrest and an email exchange between USCIS officers seeking to terminate her DACA application in a way that could not be FOIA'd, that all of that gave rise to an inference of retaliatory motive that precluded summary judgment. And in fact, a number of courts have relied on that proximity in time. It can be a really, really helpful factor. There's similar language in the Bayo-Reyes case out of the Ninth Circuit. Bayo spoke publicly at a rally and read his poem entitled Dear America, in which he criticized ICE practices. And less than 36 hours later, ICE revoked his bond and rearrested him. And so the Ninth Circuit said, the timing of ICE's decision to rearrest him is highly suggestive of retaliatory intent. And they actually pointed to other case law saying, that alone can be enough to show retaliation. The other helpful thing that I want to flag about that decision is how it relates to the Nieves v. Bartlett case, a Supreme Court decision that says that the presence of probable cause generally will defeat a retaliation claim in the criminal arrest context and in the context of damages. But the court said, we're not gonna apply that case here. I want to point to a couple of other cases where the court relied on declarations as evidence of retaliation. In Rugbeer v. Homan, the court relied heavily on a declaration by a New York City minister who basically blamed, the minister discussed the New York City field director's comments and about how he blamed Ravi and Jean Montreval's comments and protests for how ICE was negatively being portrayed in the press. Similarly in Gutierrez Soto, the court relied on a sworn statement from the National Press Club's director saying that ICE officials had suggested he and others tone it down when it came to drawing attention to the reporter's case. And Emilio was arrested and detained after accepting a Freedom of the Press award at the National Press Club, where he had rebuked ICE's immigration policies. Definitely if you're thinking about bringing one of these cases, think about attaching declarations from individuals who are present for any sort of inculpatory comments, emails, etc. by ICE. I want to flag some barriers that you will encounter if you bring a retaliation claim. These are powerful cases. They're important for the movement, but they are hard cases. I won't sugarcoat that. And the first is that ICE will generally seek to dismiss a federal district court complaint under 8 U.S.C. 1252G, which strips district courts of jurisdiction over any cause or claim arising from decisions to commence removal proceedings, adjudicate cases, or execute removal orders. So how do you get around this jurisdictional bar, right? You really have to argue that your case does not involve those three specific actions. So the Ninth Circuit in the Bayo case said that bond revocation is not one of those three things. This came up in the NWDC resistance case, but the court said, hey, this is an organizational plaintiff. They're certainly not trying to challenge their own removal proceedings or anyone else's. So think about distinguishing your case. The second big barrier with retaliation claims is this terrible decision by the U.S. Supreme Court in Reno v. AAADC. And there they held that immigrants have no constitutional right to assert a selective enforcement claim as a defense to deportation. It's terrible, but they said that there is a potential exception for the rare case of outrageous discrimination. They didn't flesh out what that is, but the Rugbeer and Rueda cases found outrageous discrimination. So be prepared to make that case. And if possible, try to style it as a case not challenging removal. So I know I'm running low on time. I'm going to skip some flags on standing. If you're thinking about bringing just a challenge to surveillance, a freestanding First Amendment claim, there's some tips and warnings here. I really want to now turn to the other side of the coin, right? If we're challenging surveillance, We have to think about DHS collaboration with private tech companies and how it fuels a system in which corporations profit from ICE raids, family separation, and mass detention, right? So just like immigrant advocates have targeted GEO for its role in the prison industrial complex, right? There is a need here to highlight the role that corporations play in commodifying data for the core purpose of profit making and targeting them in litigation and corporate responsibility campaigns. Example here is a lawsuit we filed against Clearview AI. I could talk about how terrifying Clearview, their facial recognition is all day long. But we're short on time, and I'll just say their database is full of more than 3 billion face prints that they've extracted from every public image on the internet. We're all in there. They've sold this tech to federal and state law enforcement, including ICE. And so Mi Gente, NorCal Resist, and 4 individual activists sued Clearview under California state laws. There are many difficult aspects of bringing this litigation. First, there's no law that perfectly captures what Clearview and other companies are doing. And that's in part because we have no robust federal data protection law like Europe. And most of the state and federal laws we do have, they're dated, they're siloed, they weren't designed to cover this sort of mass surveillance. You have to be really creative with your claims. And there are 4 buckets very quickly that I would ask you to consider. Tort claims, we brought a tort claim and the Clearview litigation. There are 4 that broadly deal with invasion of privacy. Look at UDAP laws, which are enacted by every state to protect consumers from unfair and misleading business practices. We also brought a UDAP claim. Think about contracts, think about state data protection laws. There are a number of other suits against Clearview, and many of them involve an Illinois Biometric Information Privacy Act claim. In just a couple of seconds, I will say these cases are really hard, but you can do it. There are some barriers. Many of the laws don't contain a private right to action, so be looking for that. And that's by design because the legislature and business interests don't want you to sue. Standing is a problem. Often if you want to be in federal court, a pure procedural violation isn't going to be enough. And so you're going to have to, think about additional injury, like whether that's emotional distress, economic injury, invasion of privacy. And I know I have to stop, but I'll just, my parting words are, please file these lawsuits, monitor the Clearview cases. They're really the first wave to target tech companies. So there are going to be lots of lessons learned. Investigate. You've heard all about that at the convening. Research state laws and lawyer up. These companies will try to intimidate you. So I'll stop there. Thank you.
Thank you, Sejal. That was amazing. And again, people can input questions into the Q&A so that we can present some of these at the end. But we're going to shift gears and hear next from Jumana Musa. Jumana is the director of the Fourth Amendment Center at the National Association of Criminal Defense Lawyers, and she is working actively to build us a new and more durable Fourth Amendment doctrine for the digital age. Jumana has extensive advocacy and policy experience on a range of civil and human rights issues. And so I'm really thrilled to hand the mic over to you, Jumana, to speak to us about your experiences.
Thank you, Jennifer. And thanks to all my co-panelists. I'm really excited, actually, not just to be part of this panel, but to be part of this convening and the fact that it has come together in the way it has. It's been incredible. I want to start a little bit where the last presentation ended, right? Which is that we do not have any kind of, I don't know why this is doing this, forgive me. You should know I'm terrible at PowerPoint, so here we go. But we do not have any, not a robust, we don't have a consumer privacy law that deals with our data, right? And that's where we need to start, because that means we have no protections in terms of what they can vacuum up and what they can do. God help me, I'm terrible at this. Okay, here we go. So here we go. But the thing that we do have when it comes at least to the Fourth Amendment in the criminal context, we always have standing. And so that's why I'm going to talk a little bit about the Fourth Amendment and what tools might be available in the world of surveillance. And I wanted to start with border searches of digital devices, because this is something that I know we've seen, particularly in the immigration context, people getting stopped at the airport, having their devices searched. I know some people don't sort of fully get what is the context. And so I think we need to start with the fact that at the border, you just don't have the same constitutional rights. It is not the same thing. It is not like being in the interior. It is not like they showed up at your house. And there's a reduced expectation of privacy in your devices, because the idea is you're entering the country, they're allowed to check to see if you're bringing contraband, things that are not allowed to be, to cross the border, things that would prevent you from entry. It is not the same, right? Depending on what your status is. So if you're a non-citizen, you actually don't have any constitutional rights at the border, and they don't have to let you in. If you are a citizen, you have some, you have lesser constitutional rights at the border, and they do have to let you in unless they can prove that you are not a citizen. And then obviously, if you have a green card, you're in the in-between space where they should let you in. You have some constitutional protections, but you're not a citizen. So what does that mean? That means, and as I know you all know this, right? We're not just talking about land borders, we're talking about airports and other ports of entry. And so in looking at what this means, the idea that you could search someone's digital devices without a warrant, I'm just going to talk about a couple of significant cases. One was the US versus Cotterman. And the thing that was significant about this particular case was a finding that you do need to have reasonable suspicion to do a forensic search of a device. So what does this mean? That means as you get there, they want to search your computer, they want to search your phone, whatever digital devices you have. If they simply open it up and flip through, that's, they're calling that a basic device, but they can and have the option to send it off somewhere where it would attach to a device that would download everything off of it. That's a forensic search, or an advanced search, as they're calling it now. And in this particular case, this is the first time they entered any type of sort of threshold of what you need to do that kind of a search, right? So that was the significance of that. That was a Ninth Circuit case. None of these cases have been Supreme Court cases, so there is no sort of ruling decision on this. And that's important to know, because these keep getting debated in different areas and keep moving in different ways. Going forward from the Cotterman case, that's when CBP sort of revised their guidance at this idea of basic versus advanced searches. Again, a basic search is supposed to be, they're not supposed to be able to download anything off the cloud. In their guidance, they make it sound like you have to hand over your device in an unencrypted and unlocked manner. There's nothing about that that is true, but they will tell you that. And what that means is like unlocked, right? Or if your files are encrypted, unencrypted. But they tell you that anyway. And the basic search is, like I said, whatever they can flip through. However, basic searches aren't so basic. It's not just a quick sort of swipe through and they go, oh, okay, and hand it back, right? Sometimes in terms of these so-called basic searches, people have had their devices taken into another room where they can't see what's happening. They don't know what the person's doing. They don't know what they're looking at. Other people have reported them lasting 45 minutes, an hour longer. So we'll get to the next case I want to talk about, which is Riley versus California, which is not a border search case. But it is significant because Riley versus California was looking at the question of whether or not you could search somebody's smartphone incident to arrest. So without a warrant, right? So normally you pulled somebody over, let's say on the highway, you pull them out, you could pat them down. If you found a pack of cigarettes in their pocket, you could look in there, see if there's contraband in it, see if they have something in their pocket that could hurt you with. Riley versus California was the case that started to distinguish really that these digital devices are different. That is not like opening up the pack of cigarettes, right? Or looking at somebody's pocket, that this really carries what they said is all the privacies of life, right? It has your photos in it, your correspondence, your now heart rate and everything, like so much information, right? And so they've distinguished that as different. You cannot search it warrantless incident to arrest. And this, of course, sort of can bolster, and I say can bolster because we're not there yet, but the idea that when it comes to crossing the border with your digital devices, do you have that protection? So far, the answer is no. And I'd like to say it was yes, but no. You still have a lesser degree of protection, but what that looks like is completely in flux. And so the next case I wanted to talk about was, and there's been a lot of cases in between, but Al-Assad versus Nielsen. The 2019 decision, the lower court decision, was significant, and it was significant for a number of reasons. In that case, they found a couple of things. That yes, the idea of borders, there's a lot of discretion, and there is an exception to a warrant rule, but that exception is not boundless. And so a couple of things that they said in that case is that, first of all, they recognized that the basic searches that CBP did are not basic. And that's already, right, that was already a concern of people's. Within the context of the plaintiffs in the case, they found things, including plaintiffs were saying that they saw them looking at emails between not the person was an attorney, but between that person and their attorney and other kinds of things they should not be looking at. The other thing that they said is that your search of a digital device, CBP search of a digital device at the border can only be limited to the kind of contraband that they would be searching for coming across the border, right? So piracy information, child sexual assault material, it would have to be something related to what would be a crime to bring into the country, right? It couldn't just be a general criminal search where you found evidence of something completely unrelated to crossing the border. And that you need reasonable suspicion. So this is a great, sort of the most sort of progressive, or one of the most progressive findings we found so far. And then it went up on appeal, and all that got shut down, which is where we are now, right? And they're looking to appeal that. But in the version, when it went up on appeal, the court essentially said, nope, they're not really a distinction. You can search for any kind of crime. The basic search is just fine. These are not issues. And so this is sort of where we're at. And so there's a lot of questions around what can you do? I think particularly for lawyers, you have to know, and I did not, this is my mistake for not sort of posting a link to the guidance, but maybe I can add it when I send my slides in. When CBP put out their guides, they put this very sort of confused bit about attorney privileged information that attorneys carry, where they essentially, like, somebody can flag it for a higher up and make a call as to whether or not this is privileged. This isn't like something clear that attorneys would want, right? Where you can say, these are privileged files, and they'll say, well, we'll get a tape team and we'll do this. It's not that kind of a clear-cut scenario, but there is something to work with, and that is something that needs to be claimed. I think the other piece of this, though, is, lawyering is not always the answer. And sometimes it is much more about your digital security, and which I would refer you to EFF's guide on border crossings and your digital devices. It's super comprehensive and it looks at every scenario. But those are just sort of like one of the ways people have been targeted is with their digital devices at the border. It's important to understand that even if we've had openings in the law, like Riley versus California, the law about border searches is still all over the map. It is not clear cut. It is not in any way protective for certain at this point in terms of what will the court say and what is the answer. I also wanted to talk a little bit about face recognition technology, right? Which I know sort of looking at the Clearview AI lawsuit is one way to approach it. It obviously comes up in criminal cases. But the other thing you should remember about the Fourth Amendment, it's not always the best tool, but it is a tool. And I'm sorry, I keep trying to look at my timer that I set for myself. So I have to go a little faster. It is a tool, but one of the things you should always know, and this comes in particular context in terms of people who are exercising their First Amendment rights, that your Fourth Amendment protections are supposed to be sort of at their height when you're coupling them with First Amendment concerns. And so some of the things we know and we've seen is that even when there's protections in place, they're not in place. So in Pittsburgh, the police department used Clearview AI on Black Lives Matter protesters, which is a violation of the department policy, which said that if you're going to use face recognition, you have to get approval, and they use a different system, right? So these were sort of people freelancing, officers freelancing on their own and using these massive tools created by private companies. NYPD used face recognition software. And this is the other thing we see on minor things, right? To track down an activist who shouted in an officer's ear with a bullhorn. And then the way they went and arrested that person was, it got a lot of attention. NYPD has frequently downplayed how often they use face recognition technology. Metropolitan Police Department in DC, it was found out later that they used a system that nobody had ever heard of before, right? If you remember the protests from last summer in front of the White House and the way that all went down, the way it was cleared and all of that. And so the reason I'm putting this out there is when it comes to face recognition use by law enforcement, it really is sort of anybody's guess in terms of what any particular department has, how do they use it, what do they use it for, and how you challenge it, because we have obstacles to challenging it. It does not mean it should not be challenged, right? And in the context of anybody who's working with people who are arrested in the context of a demonstration, I would tell you first, NACDL does have a First Amendment strike force that does look to partner people with pro bono attorneys. So that is something for you to look for if they're being targeted for their protest activity. But some of the obstacles are the lack of notice. And when I say lack of notice, like I said, sometimes people don't even know the system, like in DC, even exists, right? Or officers are using systems off the books that are not the system that their department is supposed to use. So it's not like you have anything ahead of time that sort of flags for you like, oh, this police department uses this system and this is what you should look for. I would refer you to our website. We have some sample briefs that give you some of the like what you can look for, as well as the Center on Privacy and Technology, which has great information on some of the flags that may let you know it got used. But the other difficulty in bringing a Fourth Amendment challenge is what they will say is these were for lead purposes only, right? This is not something that has to come forward to the court. And so we just ran this for lead purposes. It helped us identify some suspects. We went and found all this other information. This is not something we have to bring forward to the court, right? So it gets buried. And that's hugely problematic. In the event you do get notice, you do have opportunities to go in to try and ask, which often gets frustrated, to ask for the software itself to see how does it work. We often get told that's a sort of a trade secret protection issue. You could ask for Brady material, right? You could ask for them to turn over not just the match that led to your client, but to look at all the other potential matches, right? Because with face recognition, this is not a one-for-one matching where it says, oh, I recognize this photo. It is this suspect. You should go find this person. It's a, well, this person, it could be any one of these 10 or 20 or 90 people that look similar to the photo you gave me, and then somebody makes a decision. So asking for those other photos, these are all sort of different tactics people have taken. But again, at least when it comes to a case, a criminal case, you do have standing at least to make these arguments. I want to talk briefly about location tracking, because this is also something that is pervasive and people don't always understand how it works. Part of what happens is the third party doctrine, which if you're not familiar with it, it's the idea that once you've shared your information with a third party, you have no privacy interest in it, right? And this goes back to, the 70s, 60s, when, your phone was on the wall, right? It's like a phone, there's a phone case where you say, because you call people up and there's a whole record of who you call and who calls you, and there's an operator, there's no privacy interest in that. Same thing with the banking case, right? Where they basically said, well, you write a check, you put it in the stream of commerce, you go to the bank, the teller knows what's going, you have no privacy interest. But we all know that what our phone records look like, what our phones do, is much different than when you had to go into a phone booth or, stand next to the wall and use your telephone. And so that's brought us forward to the US versus Carpenter, which was looking at historical cell site location information. But it also built off of Riley in terms of why these digital devices are different and why the information that they collect is different and how to distinguish that. And so in the context of US v. Carpenter, there's some things that they looked at. They talked about how these phones are so pervasive, people use them so often that an alien coming to Earth would think it was actually a part of your body, right? And some of the things they talked about was the deeply revealing nature of the information that you could get from your cell phone, from these smartphones. They talked about the depth, breadth, and comprehensive reach of what these location tracking could tell you. It could talk about, it could tell you about your faith, whether or not you're a member of Alcoholics Anonymous, if you're pregnant, if you go to, whatever kind of service, whatever kind of meeting, you go to an NRA meeting, you go to a, you name it. It talked about the collection being inescapable, right? And the automatic nature of the collection. So if you're going to use the phone, it is going to collect this information. You can't opt out of it and still use the phone. It's not a functional phone anymore. And then there's a question of efficiency gain, which is, does it give police far more authority than they would have had if they had to go around and collect all this information on their own? And so I want to just highlight two things that can be relevant, particularly in the context of demonstrations. One is tower dumps. Now, US v. Carpenter said, this is narrow. We're just talking about your historical cell site location information. So basically where your phone has tracked you in the past. But everybody's been looking at how do we apply these going forward. So one of the ways we've explored is tower dumps, which is when the police go to a company, say, look, we need to know all the phones that connected to this particular cell tower, right? Because they're trying to figure out what phones connect in a particular geographic area. And the second one is geofence warrants. And that's when police have no idea who a suspect is necessarily, but they want to know everybody whose phone has connected in a certain geographic region during a certain time frame. For both of those things, they are not necessarily the 100 and some, 127 days of tracking that happened in the Carpenter case. They don't happen over that period of time, but they happen over a broad swaths of people's information. And those are some of the arguments we make with geofence warrants. We've very much made the argument that it's a general warrant, because the first step of a geofence warrant, according to Google, in a case that we've been litigating called Chaudhry, and you can find the information on our website, the first step is they have to search all of their users that they have location history on to see, to see if they've connected in that area, right? And so in order to search all of the people, they said that's numerous tens of millions of people. So these are some of the tools we have to try and get at that. And I will say, if you have any of these cases, we do trainings, we have resources, and we actually do direct assistance for defense lawyers in cases dealing with these tech issues. So you can get us at 4AC at necdl.org. And in the meantime, get your tinfoil hat and engage.
That was fantastic. A lot of information. Jumana, I know there were some questions about a guide you mentioned maybe about 7 minutes ago. It might have been through EFF, but
it is, and I'll put it in the chat.
Frontier Foundation.
Yes. I will
if
put it in the chat.
if it's possible to put in the chat as well as the website to the sample briefs, that would
Yes.
be wonderful. But thank you so much. Okay, last but not least, we're going to hear from Vanessa Del Valle, who is a clinical law professor at Northwestern Pritzker School of Law's MacArthur Justice Center. She's worked on class action litigation related to the use of gang databases and collaborated with organizing campaigns to abolish the use of such databases. We're thrilled to hear from you. I will hand the mic over to you, Vanessa.
Thanks, Jennifer. I'm so honored to be on this incredible panel. I will be sharing my screen in 1 second, and I hope you all can see that. Can everyone see that? Yes? Thumbs up. Okay. So I'm going to be talking today about a very specific surveillance tool, which is gang databases. And this came to our attention or came on our radar during the representation of one of our immigrant clients who was targeted by ICE for his wrongful inclusion in CPD's gang database. So what are gang databases? Well, in Chicago, the gang database isn't a standalone system. Rather, it is part of a larger data management system that CPD uses for all of its data management needs, which is called CLEAR. And how one gets into the gang database is through a number of mechanisms, but the two main ones being gang arrest cards and gang contact cards. So whenever an officer stops someone and they arrest them and they suspect that person is gang related, they'll fill out a separate what's called gang arrest card, and that's how the person, and then upload that into the system. Or even if it's not an arrest, but an officer just stops someone to talk to them and they suspect that they're in a gang, the officer can then fill out what's called a gang contact card, and then they'll upload that into the system. So information in CLEAR in these databases dates back to about the 1980s. And Chicago's gang database was huge. It has, we estimate to be about 161,000 people, which is about 128,000 adults and 33,000 juveniles. The Office of Inspector General in Chicago conducted an audit of the gang database, just specifically focusing on the gang arrest cards, and found that there were about 134 people who were just in the gang database through these gang arrest cards. So that's really large. It's one of the largest gang databases in the country. It's larger than the whole state of California's gang database, which is about 100,000 people. And it's even larger than New York City's gang database, which is about 17,500 people. So it's rather large. And not surprisingly, 95% of the people in the gang database are Black or brown, with 11% of Chicago's Black population being in the gang database. So how does someone get in the gang database? Well, that's the problem. The officers have unlimited discretion to include people in the gang database. So they can stop someone, and because of the area they're in, they can add them in because of the clothing they're wearing, the colors, any tattoos that they notice. All of these are reasons for officers to include people in the gang database. And sometimes they don't even have to give a reason, because they could just claim that the person self-admitted. And that's generally what they did when they couldn't find a reason. And obviously you can't, to disprove self-admit, it's the person's word against the officer's word. So there were a lot of people who were included under that category. Now, this gang database is filled with errors. It has a number of false entries, people who were wrongfully included, just a lot of false, like, technical entries. For instance, there were people listed in there who were over 100 years old, which was just not possible. There were people in there who were included as in more than one gang, and many times included as members of rival gangs. So it was just filled with errors. And then additionally, they had people in there who were in their 50s, 60s, and 70s and 80s, meaning that once you were included in the gang database, it was a permanent label. You could never get out of it. So even if people had aged out of what's generally considered, time that you would spend in a gang, you would be in there forever. The data that we received also showed that the officers were targeting youth of color. So for the juveniles who were listed in the gang database, we were seeing people who were in there as young as 10, 11, 12 years old. And for the adults who were in the gang database, we could tell that they were added when they were young. So about 15.7% of the people in there were added before they turned 20 years old. So this gang database is not only maintained within CPD, but then it was then shared with a number of other external agencies, specifically about 500 other law enforcement agencies. And this is a list right here of the top 10 external agencies who access the gang database, which the OIG discovered in its audit. And you'll see on here that ICE is a frequent accessor of the gang database, along with other federal agencies like the FBI and Alcohol, Tobacco, and Firearms, along with also Chicago Public Schools, the Illinois Department of Corrections. So a lot of other external agencies are accessing this gang information, this false gang information. And then that leads to a lot of problems, right? Because now people are using this false gang label, and it then affects other aspects of people's lives. For instance, it has, as I explained at the beginning, immigration consequences. ICE was using this false gang information to target people for immigration proceedings. We knew of people who were losing employment opportunities because their employers found out about the false gang label. People were losing the ability to get professional licenses or to get, at least in Illinois, a concealed carry license. Because of the false gang label, they were denied these licenses. It could also affect housing, your ability to get bail or bond, parole, parental rights. There's a lot of different external consequences to having this false gang label on your head. And in addition to all of that, as you would also expect, that if CPD suspects you're a gang member, it opens that person up to more police harassment, more unreasonable searches and seizures, more unreasonable false arrests. So it was impacting a lot of people's lives in a number of different ways. So we joined with a coalition of community organizers and activists throughout the city who were fighting to expose the gang database and also to abolish it. And so we were part of a multi-pronged campaign to abolish the gang database. And one of the prongs was filing a lawsuit and seeing how far we can go in the courts with getting some harm reduction. So we filed a class action lawsuit titled Chicagoans for an End to the Gang Database versus the City of Chicago in June of 2018. And this was filed as a class on behalf of everyone who had been in the gang database or would be included in the gang database in the future, with a subclass of people who were Black and Latinx. We had 4 individual plaintiffs, all Black and brown men who were wrongly included, and additionally 6 organizational plaintiffs that were Black and brown community groups throughout the entire city. And we focused really on 3 federal claims. So the first federal claim we focused on was the 14th Amendment denial of due process. Now, this was probably our most creative claim and one that was the most challenging, but we really took the lead from a number of cases related to the no-fly list that have been litigated throughout the country. So this doctrine is a very specific doctrine that we relied upon, which is called the stigma plus doctrine. So the stigma plus doctrine says that a government cannot publicly stigmatize an individual, and then that individual then suffers an additional loss of an additional liberty or property interest as a result. If that happens, then the 14th Amendment kicks in. So there's obviously these 2 prongs. So to prove the first prong, that was fairly easy. Like, there's no doubt that gang designations will be considered a stigmatizing label. It implies that someone's engaging in criminal activity, which is stigmatizing. And also CPD publicized that stigmatizing label by sharing the database with all the third parties. So we didn't have any problem with proving prong 1. Prong 2, which is the plus prong, is the more challenging part, where you have to find individual plaintiffs who then satisfy the second prong of suffering the loss of an additional liberty or property interest. So courts have recognized general liberty interests in a wide range of contexts, such as employment, licensing, education, and travel. In addition to those categories specifically related to this doctrine, courts have also said that if the stigmatizing label alters or eliminates a previously recognized legal status or right, then it qualifies. So just to give you some examples, so one of our plaintiff Dante Lucas, he was denied the concealed and carry license because of the gang designation. And under Illinois, he had a right to a concealed and carry license. So because the gang designation altered that right, we argue that it qualified as a plus prong. He was also denied employment as a result of the gang designation, and that was another way to meet the plus prong. Our plaintiff, Jonathan Warner, he was subjected to frequent stops and harassment by officers because of the gang designation. So his 4th Amendment rights were being violated. So the gang designation was altering his federal constitutional rights. Our plaintiff, Lester Cooper, he was denied an I bond for just having a normal traffic violation. Generally, if you get into an accident, you get a ticket and then you show up in traffic court. But for him, because he had the gang designation, he was denied that I bond, taken into custody, and then placed on house arrest and electronic monitoring. So his liberty interest in travel was altered. So that was his plus prong. So there are a number of different categories or ways that you can qualify under this plus prong, and those are just some of the ways that we got our plaintiffs in. And once you prove these two prongs, then you have to prove that the law enforcement agency, CPD, wasn't providing any basic procedural protections prior to publicizing that stigmatizing designation, which in our case was really easy to prove because they weren't. The other big claim that we relied upon was the 14th Amendment equal protection claim. So this, we said that CPD's conduct in targeting the class members, the subclass members, and our plaintiffs for inclusion in the database was motivated by a discriminatory purpose and had a discriminatory effect. So to prove discriminatory purpose, we argue that can easily be inferred because of CPD's long history of targeting its gang suppression efforts against people of color, its long history and documented history of racial animus, which was documented in a number of task force reports and the DOJ report, really well documented and admitted to by the mayor of Chicago, and all the disproportionate numbers that we were seeing of Black and Latinx people overrepresented in the gang database and white gangs underrepresented. So we argue that discriminatory intent was allowed to be inferred. Same thing for discriminatory effect. We had a number of statistical evidence to prove that Black and Latinx people were the ones targeted for the gang database. White, even in places where white people were stopped at relatively higher rates by officers, they still were less likely to be added to the gang database than Black and brown people. And we were able to then argue that Black and Latinx people then suffered disproportionately the consequences of the false gang labels. And then the last big claim that we relied upon was the Fourth Amendment claim, which is fairly straightforward, again, arguing that the gang designations lead to false arrests without probable cause, and that the gang designations are a way for the officers to falsely manufacture reasonable suspicion for unlawful searches and seizures. So again, pretty straightforward claims. So what were our demands in the lawsuit? Well, we knew that there were limits to what we can do in the lawsuits. We knew going in, and our clients and the coalition we were working with knew going in, that the court wasn't going to say, get rid of the gang database, that wasn't what we could be asking for in court. So we went in knowing that this was a harm reduction strategy. So we were asking for simple due process protections, along with some transparency around the gang database, and also that the CPD stop sharing the gang database with third parties. Now, the city quickly moved to dismiss our case, but then had a change of heart shortly thereafter, and then decided to try to negotiate with our clients on a new gang database policy. So after about almost 2 years of negotiation, the police department put out a new gang database policy called CEIS, the Criminal Enterprise Information System, which adopted a lot of the demands that are harm reduction demands that our clients were pushing for. So in this new policy, there's going to be stricter criteria for how people get entered into the gang database. They can't get entered just based solely on where they live, the color of their skin, the clothes that they're wearing, or tattoos that they have. There's going to be there's a lot stricter ways and for officers to get approval to include them in the gang database. People also can get removed after 5 years if they haven't been arrested, charged, or convicted of what's considered a qualifying criminal offense in the policy. And this was, again, huge because before, once you were in the gang database, you were in it forever. So now there's a way for people to be removed. And there's also a way for people to find out if they're in it, which was before people were in it and they never knew that they were in it. So there's a notice system that's set up in place, and that you can figure out if you're in it, and if you're not in it, you can get official documentation saying that you're not in the gang database. If you are in it, you get official documentation explaining why you're in it with the evidence that is supposedly used against you to prove the gang designation. And if you are and if you do find out that you are in the gang database, there's a process that you can go through to appeal that designation, which again did not exist before, which you can appeal through an independent third party and try to get removed from the database. There also be annual audits and purges of the information to make sure that the information in the database is up to date and accurate. And the database is not supposed to be used for any other purpose except law enforcement purposes. It can't be shared with third parties, for instance, for immigration, employment, education, licensing, or housing purposes, and it can under no circumstances be disclosed to ICE. In addition to those wins that were in the policy, our clients also were pushing for some additional demands that we got that the city represented to the court in writing that they would do for the database, which was essentially stopping the use of the old database by walling off these gang arrest cards so no one has access to them, along with putting some disclaimers so people understand what type of, how the information is supposed to be used, and also requiring user agreements with the third parties so that they understand and have to abide by rules about how they can use this gang information, and also transparency around this whole process. So there's going to be a public dashboard that kind of publishes the aggregate data of all of this. So after winning these additional demands, our clients, because they obviously were not endorsing any new database at all, and they understood the limits of the lawsuit, decided that they had taken the lawsuit as far as they could, decided to voluntarily dismiss their claims in September of 2020, and our individual plaintiffs settled with the city. And I'll just end by saying, so again, this was part of a much larger campaign to fight these surveillance tools. And in addition to the lawsuit, we're also working on an ordinance to pass at city council to abolish the gang database. We're engaging in public education throughout the city, through teach-in, block parties, the use of media to educate people on this and to explain to them why it's harmful, and also pushing for a public hearing in city council to talk about this, to have conversations. And so everyone is aware about the harmful effects of these surveillance tools.
That was great, Vanessa. Okay, the second secret password is SEED. Okay, so SEED for CLE purpose, SEED, sunflower first, second word SEED. I wanted to make sure people got that because I know we're right up at the end of the hour. Before we break, I'm going to just bring Jumana's attention to one question that we got in the Q&A about searches when people are leaving, not just arriving, but leaving the US by air or land. And so I'm hopeful that Jumana, you might be able to address that question. And then just one question before we break for any or all of the panelists, and the panelists can be free to take a pass as well. We've covered so many different claims today. We've talked about the First Amendment, the Fourth Amendment, different components of the 14th Amendment, state law claims, whether arising out of state constitutions or statutes or common law. And I wanted to come back to something that Sejal had said during her remarks, where she said, you know, bring these claims. We want to see them brought. We want to see litigation developed. And so my question for the panelists is, of some of the things that you've discussed, is there one or two areas in which you would actually most like to see people replicate and bring more claims? And relatedly, are there areas where you might say to folks, you know, if you're doing this for the first time, or if you don't have the adequate sort of support, this is where you might sort of talk to us and tread a bit more cautiously, right? So just if really at the end of the day, if the panelists have like final practical advice to attorneys who may be listening, to what extent are there claims that you would really like to see people develop? And conversely, to what extent might you ask folks to, you know, kind of just proceed slowly and cautiously? And any of the panelists can jump in with a response, or you can feel free to pass.
Well, this is Jimena. I mean, what I would say is bring all of the claims. And if you don't know how to bring the claim, we can probably help you do that. We have the information. This is, again, in the criminal context. It's not, we're not doing impact litigation, but you know, to the extent these things come up, the reason that we exist in the way that we do is we really feel that in order for these things to be countered and to get better legal doctrine, judges need to be aware of what's happening, and they need to understand that it's not a one-off or you know, an outlier, but this is happening with consistency. And so that's why we try to make our stuff easily available. We have, trainings online. We have lots of things you can access, or you could just get in touch with us. But from our perspective, the more you bring it, the more the word gets out there, the more likely we are to start to get some limitations on what they're able to do.
Thank you. Sejal or Vanessa, do you want to hop in before we conclude?
Yeah, I mean, I would just quickly say that, we all know that this litigation is really hard, but, I would say, like, I would encourage people to I'm going to +1 to everything Jumana said, but, I would just say, like, especially on this sort of this new wave of cases of challenging, private tech, it really hasn't been done. And so it's just like a blank slate. And so, I think it's really important to really test the waters here, try state court, let's try different kinds of laws. And even if we fail, like in the courtroom, I'll say we're going to show how the laws we don't have, like how the laws we have are not sufficient, right? And so even if you don't win in the courtroom, maybe, the campaign helps new local policies or new state laws pass, or even with, the new CCPA in California, like there are exceptions for data brokers. Like the law is not perfect, and we really need the California legislature to fix that law. And so I think even if we fail, we will help with all of that advocacy. But just also this litigation is, I think, so important to centering directly impacted communities and elevating, like telling the story about the ways in which overpoliced communities are experiencing this mass surveillance and retaliation. So, even the sort of litigation and campaign can still help build power, short of winning in the courtroom.
Yeah, and I'll just quickly add, I second everything Sejal said. When we brought our case, we knew we weren't likely going to win in court. And it was really about supporting the movement on the ground and helping that and using the lawsuit as a tool, but knowing that it was, again, just part of a larger campaign. And it was centering impacted voices, bringing their causes to light, and really like giving them some leverage to use, but knowing that we were just there to help the communities who've been working on this issue.
Wonderful. Thank you. With that, I'd like to thank all of the panelists. Thank you to the organizers, and especially to the attendees. And with that, I think we'll conclude.
I'll just hop in and say that there was a request if any of the presenters wanted to share their email addresses, that there may have been some other questions that came up. So if you just want to put those in the chat, that would be great. And yeah, thank you everyone for coming today. We hope you join us tomorrow. Our final panel will be at 10 a.m. Eastern, and it's called International Perspectives on Migrant Surveillance and Digital Identity. And we'll be hearing from panelists who are based out of Mexico City, Nairobi, and Toronto and Brussels. We will see you then. Thanks again.